Ryan Brown from J. Ryan Brown Law. It is, excuse the jacket. It's balmy, like 20 degrees in Noonan today, but we're talking about DUIs again today. We've been talking about them every Friday this month. And today we're going to talk about kind of a little nuanced issue that can come up in DUI cases. So, when you have a DUI case, oftentimes you're facing or fighting on two fronts. You're going to have an administrative case that's handled in the administrative courts. There's other options to that, like ignition interlock and stuff like that we've talked about. But a lot of times you're going to have an administrative case and a criminal case. In the administrative case, there's no prosecutor, right? The officer who arrests you represents kind of the Department of Public Safety or the state or the government's interests, whereas you are on the other side, hopefully with your lawyer. Depending on whether you refuse a chemical test or consent can impact the suspensions that are available to or that the suspensions that you are at risk of incurring. However, we can negotiate with the officers to try to avoid those suspensions. So there are a lot of different ways to do that. But what we're talking about here is mainly one issue that comes up rarely. Administrative courts usually move pretty fast. And that's good because it is to our benefit to resolve the administrative court action first. The reason is we have some leverage in negotiating with the administrative in the administrative case if we still have the criminal case. We may say, hey, we will plead guilty in this criminal case if you'll give me my driver's license back, something like that. However, and the cop oftentimes has incentive to agree to that because they don't want to have to go to trial or go to court or whatever. They may say, hey, if you'll plead guilty, so you have a DUI on your record, I'll make sure you can drive. For some people, that makes sense. They need their license. Other folks may say, hell no, I'm fighting this tooth and nail, and that's not an option. It's a case-by-case analysis with the client and the lawyer. However, if you resolve the administrative case first, all of a sudden, we lose all of our leverage. So maybe you go enter a plea because you get a decent deal. Maybe it's your second DUI, and they're going to let you take something that treats it like your first. Well, maybe that decision by the prosecutor pisses off the police officer. He may insist on going forward with a license suspension, and he can put you in a tough bind with that. So we always recommend that, unless there's some extreme circumstance, that almost always it is way more beneficial for our clients to resolve the administrative side of their DUI before the criminal side. It's very important. So make sure if you have a DUI, you're talking to your lawyer about this stuff. And the lawyers out there, make sure, we're considering. It's easy to kind of get caught up in, we've got a good deal or something. We've got to be vigilant in making sure that we're protecting against maybe a vindictive officer who does not like the outcome in a criminal case and wants to really take it out on us when it comes to the administrative courts. So good luck out there, guys. And if you have any questions, make sure you talk to your lawyer about your DUI